Sit down. Please take your seats. We would like to reconvene as soon as possible. I also would like to mention that if you would like to read, not during the presentation here, but at a later date, David Bernstein's excellent article on platform liability, which many of the panelists were referencing and talking about. It's called Reasonable Anticipation. Well, it's about reasonable anticipation. It's 2011 Stanford Technology Law Review number 9, 2011 Stanford Technology Law Review number 9, and it is indeed a great article. So I would like now to introduce the moderator for our second panel, and then he will introduce the panelists. His name is Jan Zecher, and Jan is from Stuttgart, Germany, originally. And he is a principal in the Munich office of Fish and Richardson. And as you may or may not have noticed from our materials, Fish and Richardson is one of our sponsors for the event today. And we're also delighted and honored to have Lisa Martens with us. Where is Lisa? Is Lisa? I don't see. Yeah, okay, Lisa's on break. I think she's out looking for some of the same kind of clothing that Fred Mostert was wearing. But Jan is a member of the firm's Trademark and Copyright Group, and he has several years of experience in intellectual property law across many different fields: trademark, domain name, design patent, and advertising. He was a scientific assistant at the Institute for Copyright and Media Law in Munich. He has his PhD in an area related to copyright law from Albert Ludwigs University School of Law. And we are very delighted to have you with us today, Jan.
Franklin, thank you very much. I will introduce you to my fellow panelists in a minute. Before that, I will tell you a little bit about what we will discuss today. We have a case for you today which has everything. More than 50 court actions filed in about a dozen countries in 4 continents. More than $1 billion of damages awarded. Prior art from a 1968 science fiction movie. A US federal judge suspecting counsel of, I'm quoting now, smoking crack. And a UK Queen's Counsellor introducing, interestingly, coolness as a criterion for design infringement. In other words, we will talk about the tablet wars between Apple and Samsung, the patent case of the century, as it has been called, or as The Guardian's Dan Gilmore found, the patent jihad you probably all have read about. We will focus on 2 things. We will focus on design aspects and trade dress aspects. What we will not cover, simply as time doesn't allow, are the utility patents. The US side will be covered by Rob Katz and by Erik Maurer, which both are with Banner and Witcoff. Rob is in Banner's Washington, D.C. office, and Erik is in Banner's Chicago office. Banner and Witcoff is the firm which in the last 11 years has filed more design patents in the US than anyone else. In the last year, I think more than the next 4 firms, and has litigated about 200 of them. That's correct? Right, so I'm really looking forward to what you have to share with us today. Who will also cover the US side is Andrea Sander. Andrea is an attorney with Microsoft's legal department in Seattle. And just in case we have a lot of practitioners here that some of you should do work for her in the future, you should be aware that this lady knows how to set a tone. Her fiancé is a marching band instructor. And what I also should mention is that Andrea will get married in 3 weeks. Congratulations. The EU side of this case will be covered by Anna Carboni. Anna is a partner with the London office of Red Solicitors. The only office of Red Solicitors. and is one of the few, if not the only one, UK practitioner who's both a solicitor, a barrister, and an appointed person to the IPO, right? Is that correct? So great to have you on the panel. What I should also mention here, I think it was last night that you told me that you have a nice little garden in Kent, which after some weeks of rain and use of heavy construction equipment by your gardener now more looks like the Glastonbury Festival. So good luck on that. Finally, and that's it from my side, a little disclaimer. My firm happens to represent both Apple and Samsung. Not in the tablet wars, but in other matters. So all what you will hear from me today is my personal opinion, and is not my firm's opinion, and certainly neither Apple's nor Samsung's. So that's it from my side. The floor is yours. Looking forward to your presentation.
Okay. Thank you, Jan. So I think we're going to need to switch presentations over.
That's not what we want to see.
Yeah.
Perhaps you can.
Yep. As Jan indicated, this is an incredibly complicated dispute that has global implications. We thought that we would start by setting the table for the U.S. dispute. That's what we'll focus on initially. The docket for this case, which was pending in the Northern District of California, has over 2,000 docket entries in the span of about 3 years. It was a contentiously litigated battle, originally filed in April of 2011. The case has been up on appeal and back from the Federal Circuit several times, and a verdict was just entered actually last week on March 6th. So we have some updates. But keeping things at a relatively high level, the original complaint included 7 different design patent claims, 6 different trademark claims, and 8 utility patent claims. Through the process, the Northern District of California has patent rules, and Judge Koh, who was the one who accused counsel of smoking crack, aggressively encouraged counsel to streamline their arguments and focus the case. Through the process of discovery and motion practice, the jury, because remember, these are cases that in the United States go to juries of lay people, the jury was presented with a case that covered 4 design patents, 4 different trademarks, we'll talk a little bit more about that in a minute, and 3 utility patents. So focusing on the design-related issues, we're going to focus just on the design patents and trade dress. This is one of the asserted design patents. It's US D504889. It relates to the overall shape of an iPad. And as you can tell, what's claimed in solid lines is both the front of the device as well as the back of the device and the surfaces of those 2 perspectives. Keep that in mind, that both the front and the back are at issue. Rob's going to get to it in a little bit. There were 3 additional design patents that went to the jury. They all generally related to the iPhone. The one on the far left is D593087. It claims the front top surface, the user interface surface of the device itself, and it has an overall rectangular shape with rounded corners, and importantly, it includes a bezel. It includes this sort of rim that framed the overall device. The one in the middle is D618677. It claims the same basic rectangular shape, but this one is really just focused on the black surface. Everybody is familiar with the Apple iPhone at this point, right? It's that glossy black glass surface. And finally, there was D604305, which is the claim to the right, which was a graphical user interface. The claim was in color, and this is exactly a picture from the file wrapper from this design patent. So relatively specific, as you can see, in terms of what was included in the claim. Turning briefly to the trade dress, there were 4 trade dress, asserted trade dresses at issue in what went to the jury. 2 of them generally related to the iPhone 3G. And what you see on the left is a federal registration. So one of the 4 was actually a US registration. And you can see, again, there was a color claim. It generally relates to the overall look of the device, the front of the device, plus the interface. And the text in the registration is relatively lengthy, and it goes into some significant detail about the actual number of rows. There are 16 icons and 4 rows. There's a description of each one of the icons that includes references to color and color combinations of the icons. And all of that is in the registration. Turning to the unregistered rights, Apple asserted essentially a similar claim as the registration, but in unregistered form. And what you see on the right is the description of the registration from the original, well, actually, this was the first amended complaint that Apple filed in the case. Again, there is a description, but it's more qualitative in nature, and it talks more about the kind of overall feel of what this trade dress embodies. The other two trade dresses that were at issue were unregistered trade dresses. One related to iPhones generally. So Apple put together kind of a combination claim that would capture both the iPhone 3G as well as the 4, as well as potentially the 4S. And they kind of cobbled together a list of elements, which is what you see on the left. And again, this is from Apple's first amended complaint. And it's a recitation of the elements, almost a claim construction of the asserted unregistered common law trade dress for the iPhone series of trade dresses. And finally, there was an unregistered trade dress claim that related to the iPad. And similar to the way Apple treated the combined iPhone unregistered trade dress, again, Apple set forth a litany of the elements that it believed made up or comprised the overall combined trade dress. So that's what's at issue. The design patents, the 4 design patents, and the 4 trade dresses. So in terms of what was at issue, there were over 20 accused products. What we've shown on the screen for you here is a representative sampling of the Samsung products and their basic design features. You can see on the far left, the Samsung Galaxy S has more rounded corners. The next one over the Infuse is a little bit more squared off. And then there were graphical user interfaces and, of course, a tablet. And what happened below? Well, as Jan mentioned, there was a $1 billion jury verdict issued on the claims. Apple lost on the tablet claims. They were out. As you'll hear later from Andrea, not all of the trade dress claims survived. But the bulk of the award and the bulk of the action in terms of a damages number from the jury related to design patent claims. The award was reduced. As I mentioned, it went up on appeal to the Federal Circuit back and forth a couple of times. The judge also reduced the award due to a couple of different issues, but most of the award from the jury was reduced due to a failure in notice that Apple had not sufficiently notified of Samsung, and because there was a later date that really should have applied, Judge Koh reduced the jury's verdict to account for that time gap. And another interesting feature that we're not going to get into too much here today is that Judge Koh refused to award any injunctive relief. So denied a preliminary injunction at the outset, denied permanent injunctive relief on all of the claims. That issue went up to the Federal Circuit and came back down end of last year. Judge Koh reconsidered whether there should be a permanent injunction entered on the utility patents and ultimately refused to enter any permanent injunctive relief. So that's the overall setting of the table from the US scene. And what we wanted to do now was take a closer look at the menu and focus on some of the key takeaways. And we thought we would present these in terms of, from our perspective, from a prosecution and litigation perspective, what can we learn from the Apple-Samsung dispute, and what are our takeaway lessons?
Thanks, Erik. And in addition to that, it was also where we are, a year later from the initial verdict. As time has set in, some of these aspects have become more significant and things have shifted a little bit. So in boiling these down to a number of different lessons that we think you guys would want to hear about, the first one is really recognizing the future and recognizing the user experience. More and more products have interfaces with screens in one way, shape, or form. And Excuse me, and with respect to that, it's important to protect those. They are protectable under designs in almost every jurisdiction. China's working on amending their law, so it will be protectable there. Still not, GUIs are still not protectable in Australia, but most everywhere in the world you can protect GUIs. So the point is, it's important that you aggressively get protection on the GUIs. Apple got protection on one of the GUIs, and in that particular design patent was found to be infringed in all of the accused phones. So that was a very important aspect of what led to the jury verdict. But as things are evolving, and as we're moving towards the future, in the short-term future, 50% of all designs are going to be screen-based designs, GUI designs, icon designs, things that you interact with screens on. So with that many, you'd expect the proportions to start shifting. When we see people graduating from design school, we see more and more people majoring in user experience and interface designs. So, so with respect to that, there's a whole separate set of strategies that apply. Obviously, we don't have time to go into that, but it's enough to know that companies need to aggressively protect GUIs just like any other designs in the past. So the two main reasons we're seeing this shift over to designs, GUI designs and experience designs being 50% are due to product migration and the Internet of Things. I'm going to talk about those quickly. Product migration is really the phenomenon of things moving from three-dimensional articles that you hold to perform a specific function or a combination of functions to moving under the glass in a general purpose product, whether it's a phone or a tablet, or, you know. So what we see here, a couple of examples that illustrate how that happens. So, and going around, we see a GPS device and a DVD player, a gaming device, an MP3 player, a camera, a watch. But in reality, people use their cell phone, right? They use their cell phone to do all of those things right now, and it's all done under the glass. So you're seeing a lot less cameras on the market because most of the camera sales are due to phone sales now. And you're seeing hardly any gaming devices because most of the portable gaming devices are your phones, and the MP3 players are your phones. And so that's one aspect why we're seeing more and more designs that are screen designs. And the second aspect is what's called the Internet of Things. And so the idea there is a lot more articles will be connected to the internet and are connected. We're seeing that, but in just a span of a couple more years in the future, when we look at the ramps, you're going to start to see more than half the articles in real life that are connected to the internet are no longer going to be phones and tablets and computers. They are going to be pallets and refrigerators and lights and security systems and all these things. So if we look around here, we've got you know, bicycles. You're going to want to know where your bicycles are. You're going to have your refrigerators are going to be attached. Again, you're going to be able to pick up your phone and turn the lights on and off in your house. All those things, which you can do today, are going to be more and more prevalent in the short term. And all of those are going to be controlled by a computer. And the control of all of those is going to be by a GUI. So you're going to start to see companies that make lights now designing GUIs to be controllable on general purpose devices. So when you look at the combination, and here the next one is kind of a graph of how things are progressing, and you can see with the year here. So we're right here at 2014 here, and almost now we're starting to see the Internet of Things surpass smartphones. But as things go, you're going to start to see Internet of Things surpassing by far the combination of tablets and smartphones and PCs. So it's just, you know, with that in mind, that's really one of the aspects of the future. Apple did a nice job, and they protected their GUI, and they were able to get relief from that from Samsung. So that's kind of our first lesson, our first point on that. The second aspect is, and this really applies mostly in the US, but don't think like a utility patent practitioner. I think in Europe, a lot of the practitioners who do design work come from the trademark world, and they more specifically appreciate those nuances. In the US, it's a little bit different because the design patent system emanated from the utility patent system. So what we have and the procedures are essentially the same. So what you have is you have utility patent practitioners that think of design work like it's utility patent work. So they think broad, narrow, and you hear that language all the time. Design patent, the particular design patent's broader, it's narrow. And you'll read it over and over in articles, and you'll read it sometimes in judicial opinions. But the fact of the matter, that's not true. A design patent gives you one scope, and you get the overall appearance of that scope, and that's a scope that you take to court with you. So the real issue, the best way of coining it, is a macro appearance or a micro appearance. If you disclaim a lot of things, so you're focusing on a small area, it's really almost a micro claim, but you're getting the overall impression of that microscope. If you go macro, you get the overall impression of that. So, and I think there's another case where that GUI that we talked about from Apple was really one of those that you would consider a macro. It included a lot of elements, and they got the overall impression of that where they were successful. So I'm using, this is the best example that I think for a short description to explain that concept. And so basically here's two different scopes of a gaming console for the Xbox. And here in this particular one, what's claimed is just the X on the upper surface. And what's claimed here is the X on the upper surface plus the way it falls down into extends down to the front, and a horizontal ribbing design on the sides. Well, with respect to the scope of these, if for just the X, I hate using numbers, but sometimes people think things better as numbers. If for infringement it has to be 80% similar, 85% similar, the amount of changes to the X there that needs to be made to get out of that scope is a certain amount. But if somebody copies the ribbing on the side, then changes to the X that exceeds that threshold might still infringe. So we don't have the utility patent thought of an independent claim and a dependent claim, or claims getting subsumed from one another. They're both totally different scopes. And protection, you really have to analyze whatever design it is, whether it's a hardware design or a GUI design, whatever design it is, and you basically need to focus on claim scopes that you don't want your competition or any other third party to make. So with that in mind, we look at this comparison here in the Apple Samsung, and when you really break it down, there's an awful lot of differences. You do have the general gridding, but if you compare the actual icons, you've got the icon in the lower left that is, the green tile with the phone in it, which is very similar. But if you look at all the other tiles, the appearance of every other tile is different. So they're really getting the bigger picture of a colorful grid of icons, and they were able to get that bigger concept. I do know that when you look at it this way, a lot of people will think that it does not have the same overall impression because you have to look at some of the micro pieces. But because they went after the broader, the macro effect, they were able to successfully win on that matter. So it's important not to always think broad and narrow. Lesson 3, and this is actually a lesson that actually ended up not hurting Apple, but multiple embodiments can be risky. We see all these situations now, but basically in the US you get one design claim. You can have multiple embodiments there, but only if they're patentably distinct. So you can attack the validity if they're not patentably distinct. But another way of attacking the validity is if you have 6 different embodiments, for example, and you can show that one of the embodiments lacks novelty, or one embodiment lacks is obvious, which is like individual character in Europe, think. But if you have that, then the whole patent goes down. So if you have them separately, usually you're going to get better scope, better rights, and better flexibility. So, but it is certainly risky to do that, and we see that in certain examples. So in the one Apple that they enforced, this is one of the patents. They had 6 different embodiments. They all, it was the front face. They all included that bezel and this general shape, but they claimed 3 features in different combinations. The round button on the bottom, which I think the kids call the belly button, but we would call it the control button. The display shape, and then the speaker hole at the top. And you can see they did them in 6 different combinations of those 3 features. So if you could find one embodiment there that's really close to the prior art, the whole patent could have gone down. Where Samsung's position, with respect to infringement may have been strong against some and not others in Apple's and vice versa. So in the litigation, they found that a set of the Samsung phones that looked like the ones in the middle where they had a more prominent bezel and a more rounded corner were found to infringe. But the ones on the right with a thinner bezel and were a little bit more square did not infringe. But I bring this lesson up as a cautionary tale, even though Apple didn't pay the price, because when you look at certain prior art, so there's a piece of prior art that we found that we were aware of based on our activity in the industry. But if you look at the front face of this particular patent or this particular commercial embodiment, you have generally a shape with a bezel and the speaker hole that's mighty close to that. So that if Samsung had brought that out and had raised a good validity defense, I'm not saying they would have been successful in that, but they look pretty close in my comparison there. If they were able to do that, the whole patent would have fell, where there would have been other embodiments that could have been good for Apple to succeed. So I would just say on this lesson is to use multiple embodiments in the US with extreme caution. And the last point that I have before I turn the lessons over to Erik is as design patent practitioners, they can make the difference. And we see this a lot. And it's at the high end and the low end. So the low end is where people are making basic mistakes, and then your clients paying money to fix those mistakes. Sometimes they're fixable, sometimes you pay the price in litigation. But then also at the higher end, it makes a big difference because you can get the applicant the best bang for the buck, which is a very important aspect. As cost increase, especially in the US where you have an examination practice and you're paying the patent office for search, examination fees, and issue fees that add up to $1,500 per case, you want to make sure you're getting the best bang for the buck. So getting that level of practitioners, that highly skilled level, you do get a return on that. And the results can be devastating on this. So generally speaking, the jury was in Apple's camp in just about every issue, except for the iPad. And when we look at this particular tablet, this design, this is the one they lost on. We can, just an initial look, you could see some issues with the shading on the side where they showed the contour. It looks like, to me, that I think that there were some consistency issues here. And then I think that they shaded the back with oblique line shading. Now, to somebody who is unfamiliar with design patents, they probably don't think twice about it. But oblique line shading generally means in the industry that it's either reflective or transparent. So what happened is Samsung's attorneys picked up on that aspect. And you could look, I mean, there are differences here. And if you look at the side profile, which is what they relied on most of the European litigation, the side profile was materially different there. But looking at the overall concepts, these are closer than the GUIs, in my opinion. These were closer than some of the other design patents that were found to infringe. But the way this, in my opinion, why this went to a decision of non-infringement is from the instructions that Samsung asked the judge to give to the jury, and the judge ended up giving to the jury. So as you can see here on the right, there's oblique line shading. So the judge instructed the jury that the oblique line shading in the figures, so that's not just on the front, which is the reflective surface of the mirror, the glass, but also on the back side, which I believe was done by mistake by the design patent drafter in this case, depicts a transparent, translucent, highly polished or reflective surface. Well, the Samsung did not have a shiny back. I don't think the Apple product had it. The Apple product had a silver painted back, if I remember correctly, but the back of the Samsung did not have a reflective surface either. So that was, in my opinion, probably one of the tipping points for why this tablet was found not to infringe. And as I said, I think it was probably done based on these groupings of lines. If they would have put more traditional non-reflective shading on that might have been enough to have won the tablet as well. And we saw how much the award was on Apple for the cell phones. Imagine what they would have gotten if they added the infringement on the tablets as well in the U.S. So I'll pass the lessons over to Erik again.
And there's a good segue here from the prosecution side, and the fact that design prosecution is very different from utility prosecution. The next lesson is that design litigation is very different from utility patent litigation in the US. And it can be critically important when you get into these disputes in the States to have litigators who are design savvy. And also, especially when trade dress claims are combined, the field of play really changes. So there are kind of three sub-points here. The first one relates to Rob's point about the shading on the back of that device, and that is that there are very minute details that can make a big difference in the outcome of the case. And although there is not an exact parallel of utility patent claim construction to the design patent world, some of these issues really do get resolved, like complicated, detailed claim construction issues, and how is this claim really supposed to be read, and minor perhaps mistakes in shading during prosecution could have a big effect at the litigation stage. The next point is that post-Egyptian goddess in the United States, it is incredibly important for accused infringers to marshal all of the prior art that is available to them early in a case, and especially non-patent prior art. Rob has already shown some of the prior art that was out there that we were aware of. But in the Egyptian goddess context, post-Federal Circuit Egyptian goddess case, prior art is relevant not just for invalidity arguments, but also for arguing non-infringement. And if you're the accused infringer, the closer that you can establish your accused design is in overall appearance to the appearance of the prior art, the less likely it is that you'll be found to infringe. So the idea is marshal all of your prior art early, not just for invalidity arguments, where, by the way, you also have a very high burden of proof to establish invalidity, but you need to use that war chest of prior art to support your non-infringement arguments, where you have a much lower burden of proof. So here's one example of relevant prior art that we thought maybe could have made a difference. There are a few examples of these. Here's one where it was an LCD screen that had a big silver bezel and rounded rectangular corners. Another one that post-Egyptian goddess potentially could make a big difference. And here's yet another example, maybe even the closest yet, particularly perhaps on that tablet claim that we were looking at just a minute ago. The third subpoint that we wanted to make, and this is, again, a unique feature of the fact that in the States these cases go to juries, is that the jury instructions, the instructions that the judge will provide to the jury in terms of how to assess these disputes and reach a conclusion can be critically important. And obviously the threshold from our perspective is always to try to use plain English. The average American juror has approximately 12 years of schooling. It's not the most sophisticated audience usually, and it's important as litigators to simplify and simplify and simplify and communicate at the most base level as you possibly can. And here, as Rob pointed out, the jury really seemed to be aligned with Apple every step of the way, and some of that might have had to do with the fact that Apple got really good jury instructions here. So 2 points to look at. The first is that just the overall structure of the jury instructions began with the discussion of the jury first finding or addressing the issue of design patent infringement, which is, and the way that the jury instructions were actually presented to the jurors, it was a relatively simple question of substantial visual similarity of the overall devices. And that is a nice, clean package when you compare it with the underlying infringement tests in the US with the Gorham standard that talks about that might confuse a purchaser to buying one instead of the other. That was in the jury instructions, but not until the jury had been instructed on this very, very simple, very basic test of overall visual similarity. And it wasn't until the jury had fully resolved the design patent infringement issues that it then turned to the trade dress issues, which, as you'll hear later, have different standards depending on whether you're talking about infringement and a likelihood of confusion analysis, or dilution, where you have to establish an erosion of goodwill around a famous mark. By the time the jury got to that, they'd already found Samsung liable on the design, 3 of the 4 design patent issues. So that's one point. The other point is that in the States, we have a system of circuit court law that, with respect to trademark issues, varies from circuit to circuit. Now, on the patent side, the Federal Circuit somewhat harmonizes our law, not in all instances and certainly not on all issues, but on the trademark side, there's a lot of forum shopping. There's a lot of potential for forum shopping because the standards that are applied in different circuits can vary significantly. And in particular on this issue of functionality, there is a lot of law, particularly when you're dealing with trade dress and product configuration, design type rights, that you could be a lot better off in one form as compared to another. The Federal Circuit has relatively good, balanced functionality law. But in this case, Apple got the best of both worlds and really had nice, clean functionality, ornamentality instructions that focused on whether the design itself was dictated by how the overall appearance was dictated by how the device functions. And in this case, that's a really favorable instruction because the way the device functions, all the stuff that thinking about the future and being sensitive to what's going to be done on these things coming next really has nothing to do specifically with the way the overall asserted designs work in this case. The final point that we wanted to make, the final kind of lesson takeaway, not surprisingly, has to do with remedies. In the US, design patent plaintiffs have, thanks, Rob. Design patent plaintiffs have a specific remedy that is available to recover infringers' profits, and that is under the Patent Act, Section 289. The way the law stands today, by statute, those awards are not apportioned. So Samsung didn't get to say, oh, well, the design only contributed this amount to my profit on that specific device, which is, of course, the result that we would expect. That kind of apportionment is what we would expect not only in utility patent cases, but also trademark cases in the US. That's not the case with respect to design patents. We already mentioned a bit about the injunctions. In terms of money remedies here, because of the Section 289 entitlement to total infringers' profits without an apportionment to individual features, 90% of the overall award was attributable to design patent infringements, and obviously it was a huge number. Even notwithstanding the reduction in the award, it's still a significant chunk of change. The other points on remedies that are important to consider is that marking is still very much an issue in the United States, and under the AIA, we now have procedures for virtual patent marking. Those are things that, especially in product categories like we're at issue here, could be very valuable, where you can have sort of a one-stop shop to identify either a product or a patent and interrelate the two and provide constructive patent notice. But as mentioned at the very outset, the failure of marking or the failure to give early notice was a significant issue in the reduction of Apple's total award. So those are our takeaways from primarily on the design patent focus side of things. And with that, we're going to hand it over to Andrea to talk about the trade dress issues.
Do I need to change which?
Here you go.
Thank you. So I am going to just skip through this first slide here because it's a bit of an overview, which we've just got very good coverage of. But this shows you, again, the types of claims that were involved. Maybe. There we go. So I'm going to skip straight to this first slide, and what I'm going to do is use how Apple leveraged its trade dress in this case to give some talking points about how trade dress works in the U.S., how it might be helpful in litigation, and I'm going to give some speculation on things that happened in this case and what Apple's thought process and what the jury's thought process may have been when looking at the trade dress. I think the first important point to cover is that trade dress is, at its core, not a separate type of IP, but in the U.S., it is a subset of trademark law. So all the things that we think of about trademark law will also need to apply to your trade dress. It still has to act as a source identifier. So when we think about a product configuration or product packaging, it still has to function as a source identifier, like any trademark would. That's a standard word mark or a standard logo mark. We also want to think a little bit about why Apple decided to leverage both its design patents and its trade dress in the case. One thing to think about in terms of trade dress is that, like your normal trademark, as long as the trade dress is still in use, you still have protection for it. So there's no sort of set end date for when you stop having protection for your trade dress. It's only when you stop using it. And also, similar to trademarks in the US, you can have common law trade dress rights. So you can assert your product configuration trade dress rights even if they're not registered at the USPTO, and we'll see that Apple did that here. So if you look at the chart that I have up on the screen, it shows each of the types of trade dress that were asserted by Apple, and we got a brief summary of those earlier. And as noted, there was only one trade dress registration, which was for the original iPhone, which is shown at the top. Then there were 3 unregistered trade dress for the iPhone 3G, what was referred to throughout the case as the combination iPhone. So those would be trade dress similar throughout every model of the iPhone that had been released up to the date of trial. And then unregistered iPad and iPad 2 trade dress. So the first step that the jury had to take, and again, I think it's important as we think about this to remember that this is a jury of lay people making all of these decisions as we go through this case. The first thing the jury had to think about was whether the trade dress was actually protectable. And they had to do that for each type of trade dress that Apple had presented. And in order to determine protectability, they had to determine that the trade dress was non-functional and that it had acquired distinctiveness or secondary meaning. And so you'll see that the jury decided that only 2 of the types of trade dress were protectable, and that is the registered original iPhone and the unregistered iPhone 3G, which looks quite similar to the registration they have for the original iPhone. They found that at a base level, the unregistered combination iPhone and the unregistered iPad and iPad 2 didn't even meet the standard of protectability. Because it's a jury, we don't have insight into why they found that. What they found was different in the evidence that had been provided. But the unregistered iPhone claim was kind of broad and kind of vague. It might not have been tight enough for them to determine that it had acquired distinctiveness. And the iPad and iPad 2 came out a bit later in time than the iPhone, so they may have felt that the evidence of acquired distinctiveness wasn't there. We can assume it probably wasn't a functionality issue because there's nothing that we would have found in the original iPhone or iPhone 3G that would be not functional that we might see show up in the next 2 iterations. So the next step the jury had to take was to determine whether the infringement or dilution claims that Apple had made were valid. And so the bottom 2 are already dead in the water. The jury's not even going to think about them at all anymore. They decided they weren't protectable, so they don't have to determine any of the claims. And so when you look in the trade dress claims asserted column up here, you'll see that your standard infringement claim was only made for the iPad and the iPad 2. And your normal infringement claim in a trade dress, similar to trademark, is likelihood of consumer confusion as to source or sponsorship of Samsung's or the allegedly infringing products. And so by deciding that the iPad and iPad 2 weren't protectable, the jury now at no point is actually going to consider this trademark infringement claim because there's no infringement asserted for any of the protectable models. Instead, they're going to jump straight to dilution, which in the US is actually a less common claim for a trade dress or trademark. So I'll talk about this in the next couple slides, but start thinking about why you think there might have been a dilution claim inserted instead of an infringement claim. And the standard for dilution is the trade dress has to be famous. The Samsung product has to be likely to impair Apple's ability to uniquely identify its product. And this is the type of dilution known as blurring. And in order to get monetary damages, the dilution has to be willful. And so one point that I think is interesting to point out in this, in my opinion, very likely just has to do with the fact that this is a jury of lay people making the decision. We see that Apple won on the dilution claims for both the 2 protectable types of trade dress, which means that they found that those were famous. Now, they found that the bottom 2 weren't even protectable, so they don't even have acquired distinctiveness or secondary meaning, but somehow the first 2 are famous. So even though there are a lot of similarities between all 4 of these, somehow 2, not protectable at all, 2, not only protectable, but in fact achieve the level of fame, which is a very high bar in the US trademark law. There's no bright line rule for fame. It covers a lot of the same types of factors as acquired distinctiveness, but it's definitely a different level of meaning in a consumer's eyes to hit the fame level. So this, I think, is a really interesting distinction that we see here and shows how, when put in the hands of a jury, things can get very interesting. So those are just the basic claims. I'm going to go to the next slide. And this is going to talk a bit about what Apple put forward as its trade dress secondary meaning and fame evidence, which gives you an idea, at least in the eyes of this jury, what hits that bar of secondary meaning and fame. So Apple, without a doubt, had large volumes of evidence about its secondary meaning and about its number of sales. So it put forward sales and advertising figures. And these numbers all are dated as to the date of the trial. It had spent $747 million on iPhone-specific advertising and $536 million on iPad-specific advertising from the date of product introduction through Q1 2012. So interesting to see that we only have about $200 million difference in advertising figure spend there. But again, iPad found not protectable, and the iPhone was. The picture up there isn't just an example of the type of advertising that Apple submitted that shows a real focus on that user interface and the elements that we're trying to attempt to allege were diluted by Samsung. So they were able to put forward a lot of really great advertising showing focus on those elements that it felt were covered by its trade dress. After launch, more than 1 million units of the original iPhone sold in only 74 days. Apple sold more than 1.7 million iPhone 4 units in the 3 days following its launch. However, note iPhone 4 was not found protectable because that was only claimed as part of the combination iPhone. And then in 2011, Apple recorded more than $47 billion in net sales revenue for the iPhone and related products and services. So it has massive numbers to put forth. It also presented survey evidence. The survey evidence was hotly disputed in cross-examination and things during trial, but they did have survey evidence where they had gone out and showed just under 600 people images of the iPhone and the iPad with the icons and the home button sort of blurred, so you couldn't tell exactly what they were. And they tracked the number of people who could instantly recognize those images as either an iPad or an iPhone. And the numbers that they found were with the iPhone 3G, they showed pictures with and without the bezel that we saw earlier. 61% of the respondents recognized the image, the blurred image without the bezel. 69% recognized the blurred image with the bezel, so slightly higher recognition with the bezel. The iPad had 57, they showed us a straight-on view and then an angled view of the iPad, and 57% recognized the straight-on view, and 75% recognized the angle view. One discrepancy with the survey there is they did not blur out the home button, which some would argue is one of the more distinctive elements of that trade dress. But interesting again there to hear those numbers be relatively similar, in some instances higher for the iPad, and again the jury still found iPad not protectable, iPhone was protectable trade dress. And then there was expert testimony as to the survey evidence and the trade dress secondary meaning as well. So this case, I think, just gives an example. We don't often see trade dress litigated like this in the U.S. So this is an example of at least one bar for the iPhone that did meet a jury standard, and then for the iPad that didn't meet the jury standard. So I think as practitioners, when you go to start looking, are you willing to litigate this trade dress, you can start thinking, what sort of numbers do I have to show? What do I have to be looking at in order to really feel confident that a jury is going to find that this is protectable trade dress? And I think the difficult thing with this case is that we have the iPad found not protectable and the iPhone found as protectable, but we don't see a huge discrepancy in numbers, which shows also that you are at the whim of the jury. So that just again shows how risky it is to put your trade dress on trial like this in front of a jury just to see what happens. So I'm going to just go through a few key takeaways, and this is going to be where a lot of my speculation comes in. But we talked about how the judge really encouraged the parties to streamline the claims that they were making in the trial. And so we had, back in the complaint stage of the trial, traditional trademark claims asserted and also some additional trade dress claims asserted that fell out, that Apple chose to remove and that never went to actual trial. So we see their icons. And this was the image of the trade dress was a pending application, so for their product configuration that did not include the user interface. And so we have to speculate, why did Apple choose to remove this particular IP? Perhaps it thought the risk of invalidation was higher, that the jury would find it not protectable, that Samsung would challenge it, that it would lose its registered rights. There might have been a greater fear there. They may have felt that their claims were less strong. We'll never really know why they decided to remove it, but I think one interesting point is that this pending application for the trade dress was ultimately opposed by Samsung at the trademark office anyhow. So really, even by putting it in that original complaint, they tipped their hand on it and it ended up being challenged. That's all stayed pending the ultimate conclusion of this trial, but the claim is still out there. So I think that is a good demonstration that even if you ultimately remove these and they don't go to trial, just by alleging them, you're putting yourself at risk to a challenge. And so you have to think really carefully about that when you're deciding what trade dress you want to allege when you're getting ready to go to trial. Just also, again, this point of the extensive evidence used in order to prove secondary meaning. The registered trade dress had extensive evidence filed at the USPTO, massive amounts of advertising, figures, but they didn't, Apple didn't have to assert survey evidence in order to get the registration for the registered trade dress. And so survey evidence is something I think that you'll really be thinking about when you're looking at trial rather than when you're looking at securing your registration. So that can be another benefit to getting that registration, is you really get the benefit of the presumption of protectability without initially going through that survey stage. Another point is that the majority of the unregistered trade dress was found unprotectable. The only unregistered trade dress that was found protectable was the iPhone 3G, which looked very similar to the registered trade dress. And to me, what this means is that the jury likely gave a significant amount of weight to the presumption of validity that comes with the registration. And so I think that's a very big benefit to having a registration. The jury is of lay people, so if you tell them, hey, this trademark office, whose entire job it is to decide whether something's protectable, found that this was protectable, I think you're going to find a jury very likely to listen to that and to say, well, I feel much safer agreeing with this because someone who has more knowledge about it than I do has already agreed with it. And then another point is trade dress allows for likelihood of confusion analysis, which arguably can be a bit more broad than the design patent analysis that will be given to a jury. The dilution standard in certain situations is even more broad, but requires a showing of fame. And so I talked about this point a bit earlier. You really need to be sure that you have strong numbers if you're going to assert a dilution argument, and I think you have to have a really good reason to do it. So to my next slide. Infringement versus dilution, why assert dilution? Again, all I have here is speculation, but we saw that Apple asserted infringement only for iPad and asserted dilution for the iPhone trade dress. The images that I have up here show and changes depending on phone, but your actual first boot up screen of of your phone will show progressing to the screen that was found to be a diluting of the iPhone trade dress. And we have to remember that the infringement standard is a likelihood of confusion, and that when we think about your common consumer booting up a phone, seeing a screen that says Samsung, and then seeing a screen that says Galaxy, and then eventually seeing a screen with a grid of icons, it's going to be much more difficult to allege consumer confusion when the consumer has been told 3 times that they're not looking at an iPhone by the time they hit the screen that looks like the iPhone. So my pure speculation is that Apple may have been worried about that argument, and so instead went straight to dilution, where they didn't have to address likelihood of confusion. All they had to show was that the fact that this screen existed on a Samsung phone impaired its ability to uniquely identify its trade dress. Final point on trade dress is just that a showing of willfulness is required in order to recover monetary damages. There is not a bright line rule for what it means to show willfulness, and this case isn't particularly helpful in defining that rule because Samsung had a bad set of facts. They had an email turn up in discovery where they had people stating, let's make a phone that looks like the iPhone. So I don't think we get much about what it means to be willful from this case, but at least we know that if you have an email in your file that says you want to make something that looks like someone else's product, you're probably going to hit the willfulness standard. So that is what I have to say about trade dress.
Excellent. Thank you very much for that. And I'm afraid we will skip the break, which we had planned for, because we are already running late. Anna, please take it from here.
Thanks. I thought you were going to say you were going to skip me. Like a train which starts late in the morning, I'm afraid it gets there late as well. So I'm sorry if I keep you from your lunch just a little bit. So I am oh, sorry, it was there. I'm sticking to the EU regime of registered community designs. As a parallel short-term unregistered community design system, there are also some national regimes, which is difficult to talk about in 10 minutes. So just for a quick bit of revision for those who already know and initiation for those who don't at all, what is a design for the purpose of the community regime? It's the appearance of the whole or part of a product resulting from its various features, and you can see a load of features there. And product itself means any industrial or handicraft item, but includes packaging, get-up, graphic symbols, and typographic typefaces. So I think it goes a little bit further than design patent protection in terms of the scope of things protected. A logo can be protected as a registered community design. And to be protectable under the designs regime, the first thing it must be is new. It must not be the same as one that's already gone before. Secondly, it's got to be a bit more different. It's got to have individual character, which means it must have a different overall impression from prior art on the so-called informed user, which I'll talk about later. And there are some technical function and must fit exclusions from protection, as you'd expect. But what perhaps you wouldn't expect is that there is no examination for registered community designs, apart from checking you've filled in the form properly or the representation is allowed. So there's no examination. So contrary to the position where the jury in the States is making a kind of assumption, well, somebody else thought this was valid, in our situation, we've got judges, no juries, at least not in the UK and not in most cases around Europe, who are supposed to make an assumption of validity, but in fact, nobody's actually examined that. It's a monopoly right, there's no requirement of copying, and it lasts for up to 25 years. And here's just a quick slide of a few examples of things that have been registered as community designs. But I'm not going to look at any of those. We are carrying on with the Apple and Samsung story, known as Samsung and Apple in the UK, because Samsung took the initiative. And as far as I can get through them, there are 5 topics that I wanted to look at particularly. One was the obvious of scope of protection of design registrations. Then there are jurisdictional issues that arise. You can play forum shopping games here. The so-called OHIM torpedo, groundless threats, which is a specific thing to the UK, and the arrangements whereby judges can order for dissemination of judgments. So these are the representations of the registered design of Apple that were in issue. This was filed in 2004. So here we have the front and back representations. Once again, you have the shading issue, which didn't really come to the fore, at least in the UK. And there you have, maybe you don't? Yes, the other representations of them. Not clearly to scale, which was a point made later. And just to give you a flavour of how things can work in the EU when you get 2 major competitors in dispute, this was just the beginning of the story, so what happened in 2011. So you'd had the launch of the iPad and the iPad 2, then Apple gets wind of the fact that Samsung is launching what they see as a lookalike, and it applies for a provisional and interim injunction in the Netherlands, then does the same in Germany. You can tell by the fact that in the chronology, the Samsung Galaxy tablets do launch. So this is all about the tablets, the 3 different types, the 10.1, 8.9, and 7.7. And then Samsung goes on the offensive and starts applying to invalidate and proceedings for declarations of infringement. And then Apple comes back and starts an action in Germany. And that's just up to the end of 2011. So just looking at the comparison of the, well, that's the Samsung. I've got some comparisons later, actually. That's the Galaxy Tablet 10.1. So just a bit more detail on those early proceedings. So in the Düsseldorf court, at first instance, the judge granted an ex parte pan-European, pan-EU injunction under the RCD. So you might think that ex parte relief is a little bit draconian in the case of a non-examined right, but that's what you can get in Germany, so jolly good for the rights owner. But then the Court of Appeal overturned the injunction, although there was one left in place. It was a national injunction, not based on the RCD, but on unfair competition law. In Holland, a similar outcome, but it started in a different way, in that Apple lost at both first and second instance under the RCD. And that was also interim injunction proceedings. And so although I've put there RCD was valid but not infringed, validity wasn't really a big issue. It wasn't properly tried at that stage. So Apple, having started on the attack, ends up on the back foot after this little foray on the continent. But these were only preliminary proceedings, so what happened next? Well, Samsung comes in and applies for invalidity of the registered community design at OHIM. So central attack at OHIM. Now, there's a provision in the Community Designs Regulation, Article 91, which says that if someone brings an infringement action in relation to an RCD in a national court, and there are designated courts, they're the same ones that deal with CTMs, which, other than for a declaration of non-infringement, the court must stay the proceedings if the validity of the RCD is in issue elsewhere, either in another court or in OHIM. So if you go in OHIM, if you know someone's likely to attack you for infringement, apply in OHIM, and then when the rights owner sues you in one of the countries, the court has a presumption that they must hold up the proceedings until you get the outcome in OHIM, unless there are special grounds to continue the hearing. So what happens next? So Samsung sues in the UK about a month later, so we're now September 2011, and they go for a declaration of non-infringement, and they also claim under this specific UK provision which prohibits unjustified threats of infringement. So if you make a threat, you say we're going to sue, and the recipient says, actually, I don't think that we're liable, they can go on the offensive, become the claimant, and sue. So you can go for groundless threats or non-infringement declaration. In this case, they did both. And Samsung also asked for an expedited trial, saying this is completely mucking up our market. We need to know an answer. Apple, meanwhile, comes in and they say, well, actually, the English court hasn't got jurisdiction to deal with the case as far as it was brought by Samsung Korea because of the jurisdiction rules in the EU. And also says, actually, it certainly shouldn't be expedited proceedings. It should be a stay under Article 91. Now, the jurisdictional rules are a sort of cascade of enabling you to choose where you can sue. So the first option is where the defendant is domiciled or has an establishment. So in which EU state it's domiciled or has an establishment. The second is if the defendant isn't domiciled and has no establishment, well, you have to look at the next place, which is where the claimant is domiciled or has an establishment. Now, it's not entirely clear what having an establishment means, but if your lawyers tell you don't satisfy that, then the next option is to go to Alicante. My clicker doesn't want to go to Alicante. So that was the next bullet on the slide. I'll just keep clicking, I think. So where there's a sort of central court which goes with, because it's where the seat of OHIM is. You can, as an alternative, agree to go into another court, which doesn't comply with rules 1 to 3. And you, if you can't satisfy any of them and you don't want to go to Alicante, you can sue where the act of infringement has been committed. But the downside of that is that in that case, the court only has national jurisdiction and can't grant pan-European relief. So I don't think I think it's being separately operated actually. So what happened was that in relation to jurisdiction, the judge found that Samsung Korea had no standing to sue Apple Inc. So it started out as Samsung Korea plus Samsung UK trying to sue Apple Inc. And they said, it's all right, Samsung UK can sue Apple Inc. because it's domiciled here, but the Samsung Korea couldn't, so there was no standing. As far as the groundless threats claim was concerned, this was based on things that Apple had said in court in Germany and in some correspondence when they'd been generally saying, we're going to sue you and have an intention to restrain infringement throughout Europe. But the judge said that was not specific enough to amount to a threat to sue in the UK, so he struck out that claim. And in relation to the stay, the judge said that Article 91 actually excludes from the rule about stays declarations of non-infringement, and Apple had come up with an argument as to why actually nevertheless there should be a stay, but the judge rejected that and in fact agreed with Samsung this really needed to be sorted out urgently and so granted a speedy trial. So I'm going to miss out the next slide. I don't know why. I'm going to jump to the next one. And go to the substantive trial, because the Court of Appeal effectively upheld what the judge had said about the stay. So it was not, the declaration of non-infringement application was not stayed. So we got to trial in the UK, just a few notable features about that. One is we got to full trial within 9 months. So that was discovery, witness statements, etc. Got to a full trial. It was a 2-day trial before a specialist IP judge in the High Court. There was expert evidence allowed specifically on design freedom and what features were dictated by technical function, but no broader than that. There's quite a move against having too much expert evidence in design cases here. The experts were cross-examined, but there were no fact witnesses who appeared at trial. So it was able to be dealt with in a fairly streamlined way. 2 days is quite streamlined in the UK. It wouldn't be in Germany. So the first thing that the judge had to deal with was whether the infringement counterclaim which had been raised in the case should itself be stayed, because that's the provision where there should be a presumption to impose a stay to avoid the possibility of parallel proceedings going on. So the judge and the Court of Appeal had previously held the declaration of non-infringement shouldn't be stayed, and now the question was, well, shouldn't the infringement counterclaim be stayed, because you have to have special grounds not to stay it. And in fact, the judge said that even though the parties agreed that the infringement counterclaim shouldn't be stayed, I've still got to deal with it. It's not up to you to agree because the regulation tells me that the presumption is towards a stay. But anyway, he decided that, in fact, there were special grounds. It was sufficiently urgent on any view, he said, and there was a real risk of injustice if the declaration of non-infringement was allowed to be heard, but not the infringement counterclaim. And so the stay did not happen. And so turning to the nub of the case, did the Galaxy tablets infringe Apple's 2004 RCD? And remember, you're not comparing the iPad and the Galaxy tablet, it is the drawings and the Galaxy tablet. He said the most important things are the registered design, the accused object and the prior art, and what they look like. It's not the iPad itself, and it's the overall impression which counts, and you used that terminology, so we have exactly the same terminology here. It's not about a list of features. However, you can't avoid going through the individual features, and what you have to do is to work out which features should be disregarded because they're solely dictated by function. What's left has to be checked against the prior design corpus, and you also have to look from the perspective of design freedom, or from the perspective of this person called the informed user, who's a bit different from the average consumer in trademark law. They're a bit more precise, they make direct comparisons side by side, a bit more knowledgeable. And so here are some comparisons. So the front surface, flat, transparent, no ornamentation, and then the rectangular display screen surrounded by the border. So pretty similar, but note the design corpus. These were just a couple of examples. So the judge said, well, they did look pretty similar, but the significance of the similarities was diminished by the presence of these features, not identically, but similarly in the prior art. And then looking at the back and the sort of side view, there was a flat rear surface unadorned, which is what the Apple had relied on for the back, whereas the Samsung one was flat, but it was adorned. It had the Samsung logo, and the whole point of the Apple one was to be completely clean and simple. And then Apple relied on what they called a thin profile, but actually when you look at the Galaxy tablet against the profile of the RCD, you see that the Galaxy tablet was a lot thinner. And so the judge said that the informed user, who in this case was a reasonably knowledgeable user of tablet computers, would look at the design side by side, would note the strikingly similar view from the front, and he said there was less extreme simplicity in the Galaxy design than the RCD, but noted that there were two big differences. So it was the thinness of the Galaxy tab and the detailing on the back. And this is where he came up with his quotes, which everyone likes, talked about the extreme simplicity of the Apple design, understated, smooth and simple product. It is a cool design. And then talks about the Galaxy tablets, and he said it looks as if they belong to the same family, but they don't have the same extreme simplicity. They are not as cool. So you'd think that Apple might be at least a little bit pleased with the cool design judgment, but very ungratefully they appealed it. And the lead judgment was given in the Court of Appeal by Lord Justice Jacob, a well-known IP judge. He upheld the decision on non-infringement. And of course, everyone quotes those bits which I put on my previous slide. But there was actually a very lengthy analysis of all the features and a description of the overall impression. So the judge went through all of it in rather painful detail and said, actually, I can't fault His Honour Judge Burse. He was right on infringement. At this stage, the judge also got a bit cross about a German court for issuing a pan-European injunction after the English judge's decision, which is a final decision subject to appeal, of course, in relation to infringement, and said that the court should have declined this jurisdiction and actually sent Apple off to go and apply to the German court to have that injunction set aside, because they were told off for applying in both places. The court also said that the publicity that had been generated by Apple in relation to the case, announcing that Samsung was infringing their designs, justified a publicity order against Apple. Now, this was not actually an enforcement directive order, because under the enforcement directive, if a rights owner wins, one of the types of relief it can get is an order for publication of the judgment. So the infringer has to say, oh, I infringed, and let's announce it in the papers. This was the other way around, and the enforcement directive doesn't apply for that. However, the court decided there was an inherent power there was a power under a specific UK statutory provision, and there was a test, is it just inconvenient to order this relief? Is it in the interests of justice? And the specific test that the judge said should apply in this case was there a real need for such an order in order to dispel the commercial uncertainty, and decided that there was. And what Apple had to do was to put a reference on the front page saying the Apple and Samsung judgment. They didn't actually have to put the whole text on the front page, but you click through to that if you're interested, and there was a statement about the fact that the court had found that the registered design was not infringed and that there was a judgment with effect throughout the EU. What actually happened was that Apple then went ahead and they published the words that had been told to them to be published, but they added in a little section in the middle and a little section at the end, and particularly the bit at the end rather upset Samsung, because it said, well, first of all, they put all the cool quotes in, and then they said that other courts had found willful copying by Samsung, and of course copying wasn't an issue in the UK case at all, it was a monopoly right, and infringement. And there had been findings in other European courts, but based on other rights. So Samsung beetled off, came back to the Court of Appeal, and the Court of Appeal got very cross about it, gave Apple 2 days to put the order, the statement that should have been put on, and ordered indemnity costs. So we have a system where you recover costs, and they were recovered on a higher basis than normal as a mark of disapproval. And so that was really the end of the story in the UK, and the only other sort of postscript is, well, what's been going on in the meantime in OHIM on the validity case, because were all these cases wrong because OHIM's actually going to invalidate the RCD, but certainly at first instance that wasn't the case. There was a technical objection. When if you saw the drawings earlier on, one of the thicknesses looks a lot thicker than, one of the side views looks a lot thicker than the others. And Samsung said, well, it looks like it's more than one design. But the office said, no, it's just the scale's gone a bit wrong. And also rejected all the substantive objections. There was absolutely piles and piles of prior art, but the overall impression was still sufficiently different for it to be a valid design. So that, needless to say, has been appealed to the Board of Appeal. And then you've got 2 more levels up after that from the General Court and then the Court of Justice. So that, in a very, very speedy run-through, takes us to the questions bit, I think.
Yes, thank you very much. There was... So, questions, please.
I have a question. About, on the American side, the surveys that were put forward and the speculation that was given about why the dilution claim was brought, trade dress dilution instead of confusion, right? In order for Apple to have proved confusion, it would have had to prove something like an appreciable number of likely consumers believed that the Samsung phones came from or were sponsored by or affiliated with Apple, right? And I think in that survey, the names of the companies would have to have been left on the phones, because there's law in the United States that says you have to approximate real market conditions when you do a survey.
So there were 2 different surveys done. The survey I talked about was the secondary meaning survey, and then there was a separate infringement survey performed by a separate survey expert. But I don't know the details of what was included in that survey as particularly, but they were 2 separate surveys.
Well, the one in which you said they took the logos off.
That was the secondary meaning survey, not the infringement survey.
Not the infringement survey. Mm-hmm. To just prove that the...
that consumers... without any marking of the brand name, could recognize the trade dress as that coming from that particular brand.
From
so
Apple.
as the source indicator for Apple.
I wonder if they took the logos off in the infringement survey.
I would have to check, but that would be interesting.
Because I talked to people sort of behind the scenes about that, and that was a really hot issue, and it's been a hot issue in other trade dress infringement cases in the United States. But particularly with regard to trade dress dilution, because in dilution you just have to prove that the likely consumer has a mental association between the 2 products, and then some courts will infer that impairs the strength of the senior mark. And to prove mental association, you might really want to take off the word marks and the logos. And yet that seems to contradict the general teachings about approximating market conditions. And so if all of that's true, it could seem to be strategically wise, if you have a famous mark, to skip likelihood of confusion and go straight to dilution. And
that
it might
is
be
interesting.
easier to prove, which is ironic. You know? Yeah.
Yes, I guess this is a related question, and I'm not really understanding proving fame in the context of trade dress? Because you mentioned 2 surveys and you talked about a secondary meaning survey, but my understanding of secondary meaning and that would be very different from proving fame. And so how exactly does one prove famous trade dress?
So the jury was given 2 instructions. They were first given an instruction on secondary meaning to apply as part of their protectability analysis, which had the standard sort of factors you can use to analyze secondary meaning. They were given a separate instruction as part of the dilution test for showing fame, which had some different factors, some overlapping factors with the secondary meaning. But they were never, at least from my perspective, the jury instructions were not very clear in explaining how fame was necessarily different than secondary meaning or a different burden than secondary meaning. It was just sort of the standard, a mark can be found famous if it blah, 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 list of factors. So I think that's very difficult to tell from this case because we're working with a jury. And I think it's very interesting to see trade dress be found famous, and it's very difficult to replicate. So I think from this case, it's very difficult to figure out how you would replicate that for your own trade dress. I think it's almost just a cross your fingers and hope that jury agrees with you sort of situation at this point.
To address just briefly the specific question about how do you survey fame, and in particular with a product configuration trade dress, the expert who worked on this one is a guy named Hal Perret, and his approach for the fame survey was basically to take the asserted trade dress and have people rank it or compare it to other things that most people would agree are fairly iconic designs. A Coke bottle, right? Things that other people could relatively quickly identify. And by getting this sort of rank order and how many people are actually able to identify just a design, just an overall trade dress configuration without any other distinguishing marks on it, how well recognized is this trade dress, this thing, this product configuration? And one of the real difficulties with proving fame in the United States is that it has to be for general U.S. consumers. So these are not niche market people, and this is the the high design 30-something in New York City, and also the grandma in Oklahoma City, Oklahoma. So it's a tough road to hoe.
Sounds like a fame standard based on I know it when I see it.
Yeah, it's kind of like pornography. You know when you see it.
Hopefully a short question. Just stepping back from the legal steps that have been so excellently described by your panel, just looking at the case overall, does anybody have any insight on these sort of ADR perspectives? Whether there was quite a lot of attempt at resolving the dispute in any way. Secondly, just linking to the previous panel, as technology develops and evolves and as designs evolve, do you think that the actual litigation itself has had an impact on the market in terms of, indeed preventing further dilution or, just protecting very strong, secondary rights and trade dress, et cetera?
I can give my opinion, and then if others have more. I know that there were several attempts to mediate the dispute before trial, and I think, if I'm correct, there was also a recent additional mediation, all of which failed. They never reached an agreement, and I think there were even situations where they were brought evidence of similar licensing deals that had been done between the parties, and they still just failed to reach any sort of resolution outside of trial. And that's all I know about it. To your second point, I think that what, from my perspective, and maybe from a Microsoft perspective, but what this case does is it shows that you can leverage these sort of amorphous design and trade dress rights that people are so hesitant to leverage. And maybe you only do it in a situation like this where your market share is being decimated by a competitor, and so it's really worth it to you. But I think it's invigorated people in at least the technology industry into vigorously looking at their designs, thinking about their designs, and encouraging to use designs as sort of a holistic IP, as part of the holistic IP protection. I think the publicity that this has raised has really helped non-IP practitioners understand the value that design protection can bring to an IP portfolio.
I think we only have time for one more question, but here we go.
Just very quickly on the injunction issue, was the denial of the injunction based on the presumption or the conclusion that monetary damages were sufficient and that could always be addressed through monetary damages?
From the patent side or the trade dress side? There were different reasons.
There are different reasons, yeah.
How about both?
Yeah.
From the trade dress side, I know that one of the reasons the judge stated for no injunctions was the cessation of the diluting conduct, and I guess one important point to mention is that in this case, the phone models were all older phone models. So by the time the trade dress injunction decision was being made, essentially all the phone models were phased out or almost entirely phased out of current production, hence the cessation of diluting conduct standard for no injunction.
And on the patent side, what it really boils down to is Apple couldn't adduce sufficient evidence to establish that the harm that needed to be enjoined was being caused by the specific features that were in the asserted rights. So whereas there's no apportionment for design patent damages, Judge Koh was very much looking for specific causation to individual features.
One of the things that you can ask them over lunch as you find them is the strategic pros and cons of having brought these claims under different legal regimes in Europe versus the United States, which we really didn't have time to get to. But it's fascinating as you think about the different modalities in the law that were used and the different outcomes. That they trying to figure out if that's why it produced a different outcome, or if it's much more nuanced than that. So, but we'll leave that. Thank you for this panel. It was great. I want to give you some very basic instructions on lunch. Lunch is immediately outside the door in the lobby, and then you get your lunch, and I guess we walk down the hall a bit to some area where you can sit down and eat it and visit with each other, and then we'll come back here in 45 minutes to an hour and try to rustle you all back in and catch up on time for the afternoon session. So thank you very much.